Interrogatories are a central discovery tool that are used by the opposition to flesh out the contentions that a plaintiff is making. There are different kinds of interrogatories, but typically you'll find contention interrogatories. And they'll ask, identify all documents, identify all facts, and identify all witnesses that support this contention. Interrogatories may also ask, do you contend X? And if you do contend it, identify the witnesses, documents, and facts. The reason on the plaintiff's side that responding fully and accurately to interrogatories is important is because there's something called a motion in limine. And if at the time of trial, there is a witness identified on the witness list or a document that's in the exhibit list, the first thing the defendants do is go back and look at the earlier interrogatory responses, and they'll go to the judge and say, these weren't identified. And a vast majority of the time, the judge is going to say, well, if you didn't identify that person, you didn't identify that fact, you didn't identify that document, you're not going to be allowed to put it in. This gets to a deeper issue that the client needs to accept responsibility for, which is there needs to be a very methodical and thorough search for documents. And in a world of electronic documents, with Slack, with email, you want to make sure that you've done your best job in bringing forth all of the documents. This is important for a number of reasons, not just the motion in limine, but if the other side has a document that you're not familiar with, they're going to beat you over the head with that for having withheld it, accuse you of doing so intentionally. And when you go to be deposed or examined and you haven't identified it, you'll be surprised. The good news is that if it's a complex case and there are a lot of documents, there are services that can come in and do the search for the documents. Now, if you get 100 or even 200 interrogatories, a lot of times the first reaction is going to be to throw your hands up in the air and say, this is really too much. What is the methodology for moving forward? What we find the best technique for responding to interrogatories, and in particular contention interrogatories, is to just have the story down. And if you've done a proper timeline and gotten all of the documents that you believe support your case in place, you start off, and when the question comes in, you cut and paste out of that listing that you have, which is your story. Here are the documents, here are the facts, here are the witnesses. And if you've done a thorough job, 90-something% of the questions will be answered through that technique. Well, what do you do if it turns out after you've answered the interrogatories, you find another witness or another document? Immediately tell your attorney, because you're allowed to supplement the interrogatory answers, and that will prevent the information from being disclosed. What a client doesn't want to do is trust that the attorneys are going to be able to do all of the work on answering the interrogatories, because after all, remember, the client was the one that was there, and the client is the one that actually witnessed the events that were going on. And in fact, it's a danger sign if your attorney is handing you a script and not relying upon your memory and your due diligence to get thorough and complete answers to interrogatories. Remember, you're the plaintiff, you don't have anything to hide.